Judicial review plays a vital role in the United Kingdom's constitutional framework. It serves as a key mechanism through which courts ensure that public bodies act lawfully and fairly, respecting the rights of individuals and the limits of their authority. As Mark Elliott notes, judicial review performs a constitutionally necessary function by holding government to standards of good administration and lawful procedure rooted in the rule of law. In 2022, Parliament enacted the Judicial Review and Courts Act 2022, which introduced significant reforms to the judicial review process. Among the most controversial elements were the introduction of suspended quashing orders and the elimination of carte judicial reviews. These changes have prompted considerable academic and professional criticism. This essay will examine the foundations of that criticism and assess the 2022 Act's implications for judicial review in the United Kingdom. It will explore the background and motivation for reform, key provisions of the Act, critical responses, constitutional analysis, and the anticipated practical impact of the legislation. The 2022 Act emerged in a context of growing political concern about judicial overreach and delays in administrative justice. The government argued that judicial review was being used excessively, leading to unnecessary burdens on courts and administrative inefficiency. One of the most significant drivers of reform was the case of R. Carte v Upper Tribunal, 2011, UKSC 28. In that case, the Supreme Court held that decisions of the Upper Tribunal refusing permission to appeal could, in limited circumstances, be subject to judicial review. Critics in government argued that this opened the floodgates to expensive and low-merit challenges. The 2022 Act responded by abolishing carte-type reviews altogether. The Act's two most prominent provisions are, first, suspended quashing orders, sections 1 and 2, where courts may now delay the legal effect of quashing an unlawful decision, giving the relevant authority time to remedy its error. While some, such as Tom Hickman QC, argue that this represents a significant increase in judicial power, others fear it may leave affected individuals without timely redress. Second, the elimination of carte judicial reviews, sections 3 and 4, removes the ability to judicially review decisions by the Upper Tribunal refusing permission to appeal, a direct response to carte. Critics, such as Joanna Bell, argue that this approach removes a key safety valve in the tribunal system, potentially leaving serious legal errors uncorrected. These provisions aim to streamline administrative justice, but also raise concerns about accountability and legal oversight. Many scholars argue that the Act significantly curtails the effectiveness of judicial review. By limiting carte appeals and introducing suspended orders, the Act weakens the court's ability to provide immediate relief and to correct administrative errors. Mark Elliott characterises this shift as taking the sting out of judicial review. His concern is that judicial review is no longer a robust check on executive action, but a diluted form of oversight. Suspended quashing orders, while flexible, may allow unlawful decisions to remain effective for a period, thereby diminishing the immediacy and impact of judicial remedies. Similarly, the removal of carte reviews eliminates judicial scrutiny in cases that could involve fundamental rights or serious legal questions. From a constitutional perspective, the reforms raise serious concerns. The rule of law requires that executive decisions be subject to effective judicial control. By narrowing access to judicial review, the Act risks insulating administrative decisions from scrutiny. As Tom Hickman warns, the Act creates a risk of reducing the balance of power between branches of government and concentrating authority in the hands of the executive. The UK's uncodified constitution depends on the courts to uphold fundamental legal principles. Reducing judicial oversight may erode public confidence and weaken the constitutional system of checks and balances. Early indications suggest that the Act is achieving its aim of reducing the volume of judicial reviews, particularly in the immigration context. However, there are growing concerns that meritorious claims may be left unheard. Suspended quashing orders are being cautiously used, though they have been criticised for leaving legal uncertainty. Legal commentators argue that over time, injustices may emerge, which could prompt calls for further reform. Ultimately, the 2022 Act represents a recalibration of the balance between administrative efficiency and judicial scrutiny. Whether this balance proves sustainable remains to be seen. The Judicial Review and Courts Act 2022 has brought profound changes to the legal landscape. While intended to improve efficiency and reduce the burden on courts, the Act has raised important concerns about access to justice and the erosion of judicial authority. By eliminating cart reviews and introducing delayed remedies, the Act risks leaving individuals without effective protection against unlawful administrative action. It also challenges the constitutional role of the courts in maintaining the rule of law. As the Act's implementation unfolds, legal professionals, scholars, and policymakers must remain vigilant to ensure that efficiency is not prioritised at the expense of justice and constitutional principle.